to the national webinar on intellectual property rights hosted by Christijodi College of Management and Technology in association with IQAC. If we kneel in front of God, He will never make a chance for us to kneel before others. I invite Richu Shaji and Ashwati for the prayer song.
Make me a channel of your peace. Where there is hatred, let me bring your love. Where there is injury, you are pardon, Lord. Where there is doubt, true faith in you. Oh, Master, grant that I may never see. So much to be consoled as to console, to be understood as to understand, to be loved as to love with all my soul.
Thank you, dears. Now I invite Aksa and Santosh for the welcome speech.
A warm good evening to all. I'm extremely honored to get this opportunity to welcome you all in this workshop on intellectual property rights conducted by Postgraduate Department of Commerce in association with Research and IPSL and IQSC. Firstly, I would like to welcome our today's resource person, Mr. Krishna Prasad sir. He is working as project scientist under Patent Information Center, Kerala. With due respect, I welcome you, sir. Secondly, I would like to welcome Dr. Anumanudi Miss, who is organizing secretary of this workshop. With love, I welcome you, Miss. Next, I would like to welcome all the faculties, research scholars who are the source of guidance and support. I welcome you all. Finally, I welcome all the participants to this occasion. At last, I welcome each and everyone to this intellectual property right workshop. Thank you.
Thank you, Aksa. Now it's time to know more about our resource person, Sri Krishna Pratap. Sri Krishna Prasad is working as project scientist under Patent Information Center, Kerala. He possesses expertise in patent prior art searching using various databases such as Google Patent, eSpaceNet, Indian Patent Search System, Patent Scope, United States Patent and Trademark Office FTC. He has conducted more than 100 searches related to various inventions and guided in IP filings. He has delivered several talks on patent search and Indian patent system. He holds master's degree in manufacturing engineering. Also, he has completed various courses related to IPR domain. Now, I invite Krishna Prasad sir to start the session.
Oh, thank you very much for the introduction and a very warm good afternoon to one and all. Am I audible?
Yes, sir.
Yeah, okay, fine. Okay, so let me share the PPT. Is it visible?
Yes, sir.
Okay, fine. Okay, so once again, good afternoon. So today in this section, we will be understanding more about how can or what can we do with our ideas or with our invention. How can we convert that into very useful products or process that can not only benefit the society, but also ourselves. So let's have a look at the topic itself, how to check the patentability status of the invention. At least to some, it must be very interesting because many of you will be having certain ideas or some of you will be having certain invention in your hands, but you are not able to take it up to a further stage, or you are not able to come up with a thing which can give you a good incentives from your invention. So for that, the best thing what we can do is we can do a proper prior art patent search and find whether our invention is already existing or not, or if existing, what are the present invention related to the things which we are doing or which we are under progress. So let's have a look at one by one, and I will be taking the section on how to do the search also, so that it will be giving you a more input towards doing an individual search from your side, rather than your, if you want to before filing the patent and all. So that will help not only to find what are the similar invention in your field, but also will give you an idea about what are the latest technologies, what are the latest products that are already in the world, which are very similar to your certain inventions. So, as in the previous section, you have already got a much clear awareness about what actually IPR is. It's nothing, just creation of mind. What all coming into our mind, if you are creating it into an useful form, that will give us an exclusive right for our inventions. So basically, there are different forms of IPR here. And one of the paramount importance IPR is, or IPR topic is what we call patent. Other than patent, there is also trademark, copyrights, plant breeders' rights, industrial design, geographical indications, and also trade secrets are also taken into consideration as a forms of IPR. Now, these are the different IPR legal system which are usually followed in India. And actually, the patents all comes under the Patent Act 1970, copyrights, it's Copyright Act 1957, and so on. For all the IPRs, we have certain acts established by the central government. Now, as in the previous section, you have totally understood about the patent, but just for a sake of continuity, I just want to mention something about briefly about the patents. Actually, patents are given for the inventions, and it should be either a product or a process. And this protection will give you an exclusive right so that you can make, use, or sell your patented invention. Not only that, it also acts as a negative right. Why it is act as a negative right? Just because if someone want to make it or want to sell your patented invention, he or she has to take prior permission from your side. Then only it can be marketed, or it can be taken to the selling or processing stage. And the protection is fully given for the full disclosure of your invention. Also, patent is basically a territorial right. There is nothing what we called international patent and all. It's basically a territorial right. If you are filing a patent in India, it is applicable only inside India. And the life of a patent is 20 years. So what are the patentability criteria which we need to focus more on whenever we are thinking about invention? There are basically three criteria. One is what we call novelty, the other one inventive step, and the last one industrial application. So if your invention is satisfying or following all this patentability criteria, then definitely your inventions can be patented. Now, let's take one by one what is actually the novelty is all about. It is something what which we call it as, it should whenever we are coming up with an invention, it should not be published anywhere. It should not be anywhere available as a prior means anywhere available in a prior use, or it should not be somewhere present in any of the already patented claims, not even in the literature parts also, such as publication, journals. So if it is present somewhere, or if your invention is having any similarity with something which is already existing, then it loses the patentability criteria as novelty. Then the second thing, which is called inventive step, one of the most important part of the patentability criteria side. Inventive step means your invention must have certain technical advancements to the existing things which are available in the invention part of the different parts of the world. Such as, let's take an example. Nowadays, we have the lots of upgradation or lots of advancement in the mobile technology. So that doesn't mean mobile cannot be patented. But if your inventive step is showing certain advancement than the previous or already existing mobile technologies, then definitely your inventions can be taken into patentability criteria or can be met the patentability criteria. Also in the inventive step, we have to give more preference to the economic significance also. Basically it is mentioning that your invention should be have not obvious to a person skilled in the art. So this is the most important patentability criteria which we need to focus on. Then the last one, industrial application. Whenever we develop something, it must be reproducible. It must be we must be able to make it so that we can take it further for commercialization, or which can be used by the industry, or it should be useful for the society. All these things has to be taken care in the industrial application criteria. If all these three criteria are met, then definitely your invention is somewhere near to the patented or patentable invention. But even if many a times what happens is, even if you satisfy your invention satisfy all the three criterias, then also there is some objection in the patent act which we call it as section 3 and section 4. In this case, we have to understand about one thing, that each and every country is having their own patent acts. As per Indian Patent Act, there are certain objection or certain statement coming under section 3 and 4, or certain exception coming under section 3 and 4, which mainly highlights the invention which are not patentable or which will not qualify for patent. Now, which are that exception? Let's take a look one by one. As in the section 3, first thing what comes to is an invention which is frivolous or which claims anything obviously contrary to the well established natural law. So you cannot come up with an invention to the patent office claiming that you have developed something against gravitational law or against Newton's law, or you have developed an invention which is more than 100% efficient. So why we are thinking about that is, already well established natural laws are available and they are experimentally proven. So you cannot means you cannot overtake or overlook that laws and claim for an patented invention. Then the second type comes is an invention which is giving or which is causing a very serious prejudice to human, animals, plants, and even to the environment. Let's take an example that someone has developed an pesticide to kill the pests which are coming or which are attacking their crops. But in that sense, in one way it is good, but in the other way you are creating a very serious injury to the pest, or you are killing the pest, which is not at all allowable by the patent office under section 3. So such invention which related to creating or giving very serious prejudice to the living things or to the environment are not patentable. Then also the discoveries which are basically abstract theory or scientific principle or discovery of a living or non-living substance in nature, these are not patentable in India. Let's take an example that suppose you have found out a new algae or a new microorganism, but that doesn't mean you have invented it. It's basically a discovery. It is all discovery means something which is already existing in the universe or already existing in the nature. Maybe you are the first person who have found it out, or who have done certain experiment and found it such it is something which is not known to the world, but that doesn't give you the patent protection. Also, you cannot formulate any abstract theory or any law and seek for the patent protection. Then also discoveries related to new form of substance, any new property, uh, uh, all that things cannot be patented. Let's take an example that, see, in the case of matters, we have different types of matters. In the case of solid, we also have different categories or different types, which we call amorphous or crystalline form. So there are different forms available. So such form, if you are already, if there is an allotropic forms available, and somehow you have found the crystalline form and you are claiming that you are the first person who has found it out, or you have developed it experimentally, that doesn't give the protection. Even if you have found it out, you have to prove the non-efficacy, means you have to show the improved efficacy than the existing substance. Then only it will come under the protection. Then there is also an exception which is called the admixture, the substance which are obtained by the admixture. Basically, what we called in the case of, if you take the example as a soft drink, in the case of soft drink, what we are doing is we are adding the colors, we are adding the sugars or the certain coloring component, and we are coming up with an soft drink. So that is not providing any what we called any new special property or a new generation of any chemical reaction and all. That is not at all claiming any protection. It's just you are just missing it and you are coming up with a new product. But in the case of let's take an example of an making of a soap, detergent, lubricants. These are formed by mixing lot of components, and you are coming up with an new chemical composition which is providing a better output than the individual ones. So that can be protected in some sense. Then also the rearrangement or duplication of non-devices which are already independently functioning, and you have just clubbed it all together, and you are claiming that you are the first person who has invented this product. Let's take an example. You have developed an what we call a table fan with a light. Actually, both these things are individually, maybe already it has got patent or already available things. So you have just added, or you have just arranged them in a suitable order to make it useful for the society. But that cannot be protected in the case of patents. Then the section 3I, it is mainly for the medicinal or in the medical science. They are mainly focused on this section. Any process for the medicinal, surgical, or diagnostic or therapeutic process or treatment of human beings or animals to render them free of disease cannot be patented. But the surgical equipments or the diagnostic or equipments can be patented, because in the case of equipments, they are actually products. And also plants, animals, microorganisms are not patentable because they are all living things. But definitely we can protect the genetically modified microorganism, because they are we are doing certain experiment, or we are doing certain research and developing a new microorganism by using the different types of gene technologies and all. So such things involves lots of human efforts, or human intellectual act is coming into the action. So such things can be protected. And in this section 3K, which mainly focus on the mathematical, business method, computer programs, algorithm, all these things are not patentable. You cannot patent an mathematical equation, you cannot patent an computer program, you cannot patent any algorithms developed by yourself. But in the case of computer program, you can in the case of software and all, you can claim for the protection, but you have to prove that you have developed the software mainly to solve any technical solution to a technical problem, or your software is mainly focused or embedded with some hardware component or attached with some hardware component, then such things can be protected. Also, literally dramatic, musical, artistic work, or any aesthetic creations, these all things are protected under copyright. So these are not protected under patent. Then also the mental act, performance, method of playing games, or developing any what we call the schemes or rules for any of the process or any of the methods you have developed for the games and all cannot be protected. But however, if you have developed certain products which are very useful for playing certain games, that things can be protected. Also, in the case of mental act, you cannot protect what we called the, you may be having certain unique method of uh, uh, verbally communicating with someone, or you may be having a better method of teaching and all. Such things cannot be protected under patent. Also the presentation of information, such as, even if this thing what I am sharing the slides with you and I am presenting in my own way, but these things cannot be protected under patent. Also topography of IC circuit, because IC circuits are one of the uh, major big breakthrough in the recent era. Many of the equipments are already embedded with ICs, but in the topography part of the ICs cannot be protected in patent. Also the inventions which are already existing in the traditional knowledge, or that came from the traditional knowledge, cannot be protected in India under patent. Just take the example, you have found a new use for the plant neem, or new use of haldi, or wound healing properties of haldi. You have found out wound healing properties of haldi, and these are the things already available from the traditional knowledge document. And if you want to know whether such traditional knowledge exists or not, we can have a look at the traditional knowledge digital library, which is providing an very open database to give you a complete idea about what all things are already available or already uh, uh, documented in the traditional knowledge. Then also there is a section called section 4. In the section 4, the invention relating to the atomic energy are not protected. You have developed something related to the atomic energy related, such as an invention related to the production of uranium, radium, or any of the radioisotopes related inventions. Such things cannot be uh, given patent by the patent office, because all these things are coming under the Patent Energy Act. And even if you have developed something related to the atomic energy level, it will be transferred to the central government, and if the government will look into that, if it is, whether it is useful, and they will take it from you. So these are the things which we must keep in our mind whenever we are thinking, or whenever we are coming up with an idea in India. So not only patentability criteria need to be met, but also we have to look into the section 3 and section 4 for strengthening our patented, or strengthening our invention for providing to the patent office. Now, the most important part, or the first part which we must do, or which we must think about, is what we call prior art search. What is the importance of prior art search? What is the need for prior art search? Why it is so much important? It's just because first we must have an idea of whether our invention already exists or not. If it is already existing in the world, we are talking about India, but we have to do the prior art search worldwide, because our invention should not be present anywhere in the world. There are different means there are different countries. Each individual countries will be having their own patent office, so everywhere someone must have filed, or someone must have documented something somewhere. And if your invention is already having any similarity with already existing documents, then the patent office will definitely show the objection from their side. So before filing, the first thing what we must do is have a very proper and very efficient prior arts patent search. Now, in after this slide, I will let you know how can we effectively do such a search and come up with a very well documented invention, so that it can be protected by the protected in India. Now, what actually the prior art is? Any scientific or technical data that exists before your invention, that comes under the prior art, or anything which is available in the public domain. Public domain in the sense means it can be available in certain newspaper articles, journals, or even in any of the patented documents. So anywhere it may be available. So our search would be very strong, so that we may get a maximum protection for our invention. Now, these are some of the examples I have already mentioned: patents, illustration, maybe in the some of the advertising catalogs also it may be available, in trades or professional journals, even in books also prior arts is available. So we have to go deeply into all such things before filing for the patent. And it may be time consuming, it may be taking more than 1 week of search also. That depends on the field of invention you are in, or in which field of invention you are creating certain product or process. So what is the need for search? Is it so much important? Yes, definitely search is very much important. Is first thing what comes to our mind is we are searching just to know whether our invention is new. While searching, if you are getting something or a document related to your invention, that means there is no novelty in your invention. So also it will help you to let you know who all are already involved in certain invention related to the things which you are taking care of. Means who already owns it, or who are already thinking about the way you are. So before doing a patent filing, the search is very important. Also, it is useful in the case of opposition side also. And many times what happens is people are in the case of certain business stage, people are they means they will be trying to launch certain products also. Maybe it's that products are already patented somewhere. So before knowing before launching a product also, it is necessary that you have to do a search, because it may be infringed with the already patented invention. Now, why patent search? Mainly to know whether our invention is new. And also one thing has to be taken care of, because the patent filing involves certain expenses, certain financial commitments, and also you have to involve lot of effort in developing the documents and all. So if you are totally involved in that invention, the first thing you have to do is the patent search. Then only you have to think about the filing side. And also the search will help you to let you know whether your document is perfectly finished or perfectly under the act of Indian Patent Act. Then only it will help you to let you in the filing procedure. Also, the search will give you more importance which all countries are already doing parallel research related to your invention, or who all are already the inventors involved in it, who are basically the owners in the existing patents. All these things can be taken up by doing the proper search. It will let you also know who are the existing competitors in the same technology, because whenever we are developing something, always there will be a competition in the world, or in the marketing world, mainly because each and every time new technologies, new process, new products are popping up or developing somewhere in some part of the world. So definitely there will be someone who will be competing with you. So you must be having a parallel idea while doing the filing, and even after the filing, who are involved in the invention related to what you are doing. Now, let's have a look how we can effectively do a patent search. Before that, I just want to mention some of the kinds of patent search which are already carried out all over the world. And one of the main search is what we call patentability search. It is basically an primary search which let you know whether your idea is novel or non-obvious, or is someone already uh, has claimed the idea, or the claimed the invention and made it patent, or converted it to patent. So it's basically the primary search. In this, you can just input your idea, and you can undergo the search in different already available patent database, and you will be getting the similar documents related to your search for considering the similarities, or having a comparison with your existing invention. Then there is also a type of search called freedom to operate search. It is mainly focused to check how similar your product is to the existing patents which are available in the public domain. And also there is a search called validity invalidity search, mainly focused to know or find which are the things which are missed or which are uh, not taken care by the patent office. Usually such these searches are done even means are done after the stage of getting your product or process patented. So it is mainly done or becomes very useful for the competitors to look into the context of validity of the granted patent. Then there is a search called state of art search. This search is very useful to the present world or to the modern world, because uh, we must be having or we must be able to identify what are the existing or what are the present technologies which are dominating the world, or which are giving more invention, or more from which field of technology the more patented inventions are coming up, and who are active in that field. All this will be taken care in the state of art search. And all this search can be followed by using the same database or free database which you are which is available in the website, means which is available in the internet. Now, how searching can be done? So I have just created a small searching steps for you. Just have a look at it, and let me know if you are having any trouble in understanding it or not. So first thing in the case of searching is to identify the keywords. Actually, that are the most critical step. Suppose you, let's take an example. I don't know how many of you are from uh, commerce, or how many of you are from science field, but I have taken example of uh, a finance management system as an example, so that at least some of you will be getting an idea about it, how we can do a proper search for the financial or invention related to the area of finance. So in that case, what we must do is, first we must identify the proper keywords. So keywords are the basic part of our search. If you are not inputting the proper keyword, then the search will lead you or misinterpret you to some other way. So first identify the most critical words, or most important words which are very yeah, or which are acting as a foundation of your invention. So that comes as a keyword. And many times what happens is, these keywords will be having different similar meanings, or alternate words will be available. So we will not be having any idea about what all words have been already used in the patent documents. So you have to uh, input more synonyms or more alternate words if you are not getting the search which are very similar to your invention. Then the third case comes is, you have to select a proper database for conducting a search. I will be mentioning some of the database which will be very useful for you. Even you can take the screenshot and keep it with you whenever you are having certain idea or invention in your hand. Just go through that database and do the search in the way I am explaining to you. That will be very effective for you in the further stages also. After selecting the database, you can perform the search and you can examine the already provided documents. You can have a comparison in if you are by considering the patented documents. They are all easily downloadable and they are in the PDF form. So there is no secrecy is maintained in the case of patent. Why? Because publication is the must in the case of by the patent office before granting. So already filed patents and must be published by the patent office, and that documents can be downloaded by you in the form of PDF. Then you can make a summarization, or you can discuss the relevant prior art, what you have found, and you can give a proper rating to the invention and make it more helpful, or more means it in a more better way, so that it can meet all the patentability criteria and it can overcome the section 3 or 4 if any comes under in your invention. Now, you need to have a proper search strategy planning. So if you have found out a proper keyword, with the help of a concept search or a concept approach, you can do your search. Now, there is something what we called IPC and CPC also. I would just want to mention this also. It is not that much necessary in the case of doing a primary search, but if you want a very advanced or detailed search, it will help you in a very better way. Why? Because IPC is what we call international patent classification. For each and every uh, product or a process, it must be some related to some specialization, or it will be related to some subject domain. So all these subject domains are classified in the IPC and in CPC. CPC also helpful whenever you are doing the search in US patent database, also in European patent database. So I have just mentioned some of the IPCs. Let's take an example. You are searching something related to finance or insurance area. So there is a code IPC called G06Q 40/00. So just by clicking or just by typing that IPC number, the it will take it will let you into all the documents related to the finance. So that will narrow down, or that will give you much advanced result than what you have expected. So that is the importance of IPC and CPC. Now, these are the websites which I have told you to take a screenshot so that it will be very useful for you. And the first website is ipindia.nic.in. This website is of Indian Patent Office, and you can do the patent search there. Then espace.net, European Patent Office free database available there. You can do all types of search, advanced, simple, and even if you want to search in by focusing on the IPC or CPC, which I have mentioned already, you can also input that. And also one of the advantage part of the such database is that many times what happens is, for let's take an example, you are doing a search and you found a Chinese document. So in China, what happens is their official language is Chinese. So the documents will be available in Chinese. But in this database, we have a provision for machine translation. So if you want to translate that Chinese document into English, you can take the help of machine translation and convert the document and make it a document which is very much understandable to you. And you can download it and you can go through it. So that are some of the provision given by this eSpace, WIPO, and all. And in the case, there is a very common database which we call Google Patent. Simply just like whenever we want to find something on Google, what we do is we will be entering the keyword and we will be doing the search. The same way you can do the Google search also. And also USPTO website is available for the mainly such database are means developed by the United Patent Database. Then even for doing the chemical compound search, if you are having certain chemicals or some chemical composition related to your invention, you can refer on the ChemSpider, PubChem, WIPO.net. In all this, you will be getting the different organic structure or organic compound which are already existing. So these are very important website which will help you in your patent search. So as an example, now I am going to narrate you how to do a prior art search related to a topic called finance management system. Let's take, we have developed a finance management system or a software or a finance management process. So we want to know whether such a system already exists somewhere, or we want to know whether how many types of management system related to finance are existing in the world. So in the case of that, I have used the concept as finance management and system. And I have introduced synonyms also. If you want, if your search is if you're feeling that your search is not that much effective, then you can also include the synonyms. And even then also you are not getting much better result, you can include the IPC patent classification numbers. and, and if you know any of the names of the inventors or any of the applicant names, then also you can input it. And if you want the latest invention related to that, you can involve the date or the year uh, around which you need the documents and all. So this approach can be taken care of while doing the search. Now, this is the Indian database front page. The web, I have taken the screenshot of the web page to make you much clear about how it looks like. So in this, there is an option called public search. So when you click on the public search, it will pop up to a new window in which the public search will be showing 2 to 3 icons, in which the first one will be patent, trademark, then design, then electronic register for patent agents. So in the first, we are means we are totally looking for something which are already patented or which are already something related to patent. Then we can click on the public search. In that public search, we can click on the patent. So when you click on the patent, a new window will be opened, and in which you can see that there are different uh, uh, labels are provided for inputting the data available, such as if you want a published doc, whether you want a published document or whether you want an already granted document, from which date to which date you wanted the document. And if you know the title of your means title of the invention which you are which you want to conduct search, you can enter it. If it is not available also, there is no issue. And if you have know something about the abstract of the invention, then also that also you can input. If there is any company you have any application number, anything available or anything which already you have with you, that can be inputted to make the search better. So I have no idea about what actually means what are the things or what are the inner side of this finance management system. So in the case of title, I have just involved the keyboard called finance or a word called finance, and the abstract side I had just inputted finance management method. Maybe in the abstract side somewhere it will be coinciding with any statement or any word related to finance management or method. So I found almost 31 documents related to the finance management system. You can see there, here is the application number, here there is a title provided, and the application date will be also highlighted, and the status will be also highlighted. So these are already filed and published documents. And in this, I found that there is in 2017, there is a document called finance management system and method therefore. So it has undergone or it has passed the stage called publication. So that's why that means the documents related to all this or the documents related to the invention will be available in the patent website. So when I click on that, what we find is we will be getting a new page. In that there will be the title will be highlighted, the publication number, in which year it was published and in which year it was filed, what is the application number, what is the field of invention, what is a see here also you can see the IPC classification. If you already knew this number, then in before entering all the title and abstract, straight away you can enter the IPC and you can give a means you will be getting a correct or very accurate documents related to your invention. Even the name and address, the nationality, everything will be available about the applicant or the inventor. So in the same page, you will be finding a view document option. And when you click on that, you will be getting all the documents which are submitted by the inventor to the patent office. So there are different forms available for filing your patent that so these things will be discussed in the upcoming sections. And you will be getting and as a and one of the most important thing which we must keep it in our mind is that in the case of patent, claims are the most active part or most fundamental part of patent. So if something need to be protected, it must come under the claim part. So here you can see the first thing they have highlighted is he has submitted the claims, and also FER report. I will be discussing all this. What is actually FER report? See, abstract, he has submitted abstract and he has filed with the help of an patent attorney. Who is patent attorney? I will let you know. And drawings, he have included the drawing descriptions, he have submitted all relevant forms required for it. So these are the documents which he have submitted. These all documents are downloadable, and you can download and you can have a review of all the submitted invention by this person. And if this is the final certificate which we'll be getting, if everything goes well, the patent office will be granting you the certificate. This is what we call patent grant certificate. In that, patent number, application number, date of filing, who is the patentee, what is the title of his invention, all these things will be highlighted in the patent certificate. So this is the Google patent database, just like our normal Google. Only thing is it will be highlighted as Google patents. In that you can just enter your keywords or the statement or anything related to your invention. I have just entered finance management system, and there is an option in the Google patent which will give you the non-patent literature also, means the publication or something, if any journals are available, all that things will be also come up with the patented documents when you click on the, or when you tick on the include non-patent literature. So I have got something, when I gone to the search, I found that in finance management system, I have something what we call, see, how it is getting the search. Toyota management system, methods, system, articles for manufacturing. For, see, it is searching word by word, finance management system. So if any invention or any title is coming with any one of this, it will be highlighting it. So see, in the third case, finance management for non-profit organization. Basically, it is an publication. So you will be getting non-patented literature also. See, there is a finance management system. It is actually an patent filed by, it starts with an JP. That means it's filed by or filed in Japan by someone. If you want to download it, you can just click on and you can download it. So this is what we call European patent database. Here also I have just entered the finance management system. See, here there is an option called advanced search also. In this advanced search, if you know the IPC number of means the invention which you are involved, or if you know any other things related to your invention, you can enter and you can do an advanced search also. So see, in this European patent database, when I have just entered finance management system, the result is more than 50,000 of documents has been found out. So from this 50,000, we have to find which one is very close or which one is very similar to us. So in that case, what we can do is we can go for advanced search. We can add the things which are most closely related to your invention, the keywords which are very closely related to your invention, words, synonyms, and by entering each time, you will, this number will be getting reduced. The document number will be getting reduced, and you will be getting much more similar documents related to your invention. So it will be very hard for you to search from more than 50,000 documents and find out which one is very close. So you have to do an advanced search and you have to narrow down the result. Then only the search will be much effective. So these are the things which we must keep it in our mind while conducting the search. Now, next comes the most important part, what to do if you invent. If you have already invented, or if you are in a stage of invention or in a primary stage of invention, what are the things you must be, or it must be taken care of? First thing, do not publish anywhere before filing patent application. Because whenever you publish it somewhere, it will lose the patentability criteria called novelty. So never publish it before filing. You can publish after the patent office published the document. Before that, never published anywhere, because whenever you publish in any of the journals or articles or in any of the newspapers and all, many times what happens is we are very curious about means intimating our invention or highlighting our invention to the world. So that time what happens is we will be including the photos. We will be explaining the functional aspect, and everything we will be publishing in the any of the articles or highlighting in some of the newspapers and all. So there itself it loses the patentability criteria called novelty. So never publish before filing the patent application. These things should be kept in the mind. Now, if you are in the initial stage of your invention and you need further research and further assistance related to your invention, but for that, in that case, what the main situation is, many times we need to disclose our invention to at least to some of the people involved in the research part, or even in the case of the financial funding area and all, we need to give them idea about what our invention is about. So that time what happens is our invention is disclosed to many person. So we will be having a fear that whether it will be protected or whether some other person will take it much faster rate than ourselves. So in that case you can go for provisional filing, in which the patent office will be giving you a 12 months time to submit the complete specification, and you will be getting the same priority date, the date in which you filed the provisional application. And also just by getting the patent itself will not give you much incentive or will not benefit you in any means. So you have to check the commercial and technical side in a very deeper way, because the life of the patent is 20 years. Within this 20 year you will be you must be able to commercialize it and make it available to the society. Then only you will be getting very good benefit from your invention. And also in this case of patents, there is a procedures in which we need to file the request for examination, whether the means after filing the patent office will publish, then we have to give the request for examination. Then only the complete document will be examined by the examiner of the respective patent office. So as soon as possible, try to get it patented or try to get it protected. Then with that protected or granted patent, you can do anything. You can make it, you can sell, even you can license to someone by proper agreement system, or you can even import, even you can export anything related to the patent system. You can, means protected patent, you can be able to execute it. You will be so even after getting the patent, first priority must be, we must be trying to go for the commercial side also. Try to make it or try to sell it. If you are not able to make or sell, you can license or assign to someone else. So these are the things which must be kept in our mind. So even after getting the patent, you must regularly have a field watch who are actually coming up with the invention related very close to your or very similar invention related to the existing ones, who are coming up with very advanced invention related to your one. What is the stage of the invention, whether it is old, new, or whether someone has taken up the invention to some next level. Everything has to be properly watched by with the help of the search method. So these are the main patent office, head office at Kolkata. Then we have New Delhi, Mumbai, Chennai, and the people in Kerala, or we are in the Kerala jurisdiction, we need to file the full patent in Chennai. So these are basically the filing procedures. This will be discussed in the upcoming section or in the tomorrow's section most probably. So in that case, all these things will be clear. The first stage will be filing, then publication, then if examination, FER report, grant of patent. Then also there is a renewal fee process is also there. If someone want to oppose also, they can oppose. So these are basically the filing procedure. These all things will be discussed in the upcoming session. So as I have mentioned a name called patent attorney, what is the need of patent attorney? Basically patents are techno legal documents So we cannot draft it very in a legal manner or in a very technical manner without help of a proper attorney. What happens is attorneys are very good at drafting the patented documents. They are very much aware about the different sections involved in the patents. They are aware about the uh, syntax part of the documentation. Each and everything are known to them. But without them, if we are taking or we are filing, we must be having at least some knowledge about the developing legal document such as patent. So they are very good at drafting. Not only patent attorney, you can take the help of patent agent also. They are already qualified patent agent examination qualified persons. So they are also good at drafting. These people can help you to make your document very effective and will increase the process of filing in a better way. So these are some of the fee schedule. I have just mentioned the e-filing fee schedule. So these are all statutory charges. As an institution, as an individual, you need to submit the forms and its respective fees also need to be submitted to the patent office. And if you are seeking or taking the help of any of the attorneys or agent, there may be certain professional charges from their side also. So that has to be taken care of while going for the filing procedure. So this is the patent office Chennai address. Actually, all the filings of Kerala are done under Chennai office. If you want any details related to the filing, and also you can definitely contact the patent office Chennai. So what we are doing, we are actually functioning as intellectual property right information center Kerala, which is basically a nodal agency related to all the IPR related matters. We are providing advice services and developing rules policies related to the matters of IPR. So these are some of our services and schemes: technical and legal assistance, support, help desk, and also we have a very good in-house prior art patent search facility, which is very free of cost. You can download the patent facilitation form from our website. You can input the what all information you have related to your invention, and you can submit to the office. We will be conducting the search and we will be providing you the documents, and it's free of cost. So these are some of our major achievements. More than 580 IPR awareness program. We have processed more than 1,000 or 1,100 patent facilitation application, filed 108 patents, 22 patents granted so far, and we were able to establish IPR cells in 27 centers, in which 10 universities, 16 college, and 1 DIC is there. And we have also published many journals, newsletters related to the IPR. So that's all about today's section. Now the platform is open for any doubts or discussion. Thank you. Hope the section was very useful for you. Thank you.
Now we are moving to our question and answer session. The audience can put their questions in the chat box. Sir, we have one question, that is, what is the time required for patent approval in India?
Yeah, thank you. It's basically a good question. Many times, many people ask the same question also. What is actually the time required for to get it patented, or from the initial to final stage? How many? What is the actual the time period required? Basically, it depends upon the forms you are submitting, because in the upcoming section it will be detailed in a better way. I just shortly I will speak in a very simplified manner. In each and every part of the filing procedure, we need to submit certain forms, and all that forms are easily downloaded from the IP India website. In that forms, suppose if you want to give it for patent office for the publication stage, you need to file the publication form, and there is an option called early publication. If you are in a hurry and if you want your invention to be patented in a faster way, you need to submit the form for early publication. And there is an provision for expedited examination. You can accelerate the process of the examination by submitting the request for expedited examination. So these are things will be mainly important, or will be mainly involved in the time period of an patent or the filing procedure time. So basically, a minimum period of usually uh, uh, 8 to 12 months will be taken in the case of an filing procedure. So now they are moving in a faster rate. I think the latest, as per the latest report, within 48 days, a patent has been granted, and that shows they are moving in a much faster rate, and there is no much time consuming in the case of the filing aspect.
Okay, thank you, sir. Now I invite Dr. Anu Anthony, Faculty Accuracy Coordinator and PG Course Coordinator of Christjodi College of Management and Technology, for giving the token of appreciation to our resource person.
Thank you very much.
Living in a state of gratitude is the great way to grace. I invite Alina Hannah George for the vote of thanks.
A very good evening to you all. It's my privilege to extend my sincere gratitude to all those who present here. First of all, I thank Mr. Krishna Prasad Sir, Project Scientist, Patent Information Center, Kerala, for the fruitful and very informative section. Thank you, sir. I also thank Father Joshi Chidamguri CMI, Principal, Christodi College, and Dr. Verghese Anthony Sir, Vice Principal and HOD of Commerce Department. I also thank Dr. Anu Anthony, Ms., Organizing Secretary of this workshop. Thank you, ma'am, for your support and cooperation. Last but not the least, I thank all the participants in and around the state for your active participation. Thank you.
Thank you, Hannah. The feedback link is provided in the chat box. Thank you all for spending your valuable time with us. We need your support and participation in the coming days also. Thank you.